I'm not asking for FMLA, I just need a few weeks. Let's start with this situation that many employers see constantly. An employee goes to their supervisor and says something like, I'm dealing with a medical issue right now. I'm not asking for FMLA, I just need a few weeks off. The supervisor wants to be supportive. Maybe the employee has been a strong performer. Maybe the supervisor doesn't want to make the situation more complicated than it needs to be. Either the employee is using vacation time or understands they won't be paid, so that doesn't seem to be an issue. So the supervisor responds with something like, okay, take the time you need and keep me posted. From the supervisor's perspective, that might seem like the right thing to do. But of course, for many of you experienced in HR, this is one of the most common ways that employers unintentionally create FMLA compliance problems, potentially among other forms of leave. So you could similarly apply this to paid family leave, although there's not as much risk of paid family leave being ignored because that actually provides compensation that the employees are usually looking for, whereas the FMLA only in itself requires unpaid leave. Let's make this scenario a little bit more concrete. And the employee tells their supervisor they need 3 weeks off for a medical issue. The supervisor informally approved the leave, perhaps just not putting them on the schedule during that time period. As a result, no one sends any FMLA paperwork, no eligibility notice goes out, no medical certification is requested. Um, Everything seems fine in the sense that the employee takes the time off and returns to work here as expected. At that point, the employer doesn't necessarily have any problems, but from a legal perspective, they may have already missed several required steps. The reason this becomes problematic is because in some organizations, supervisors think about leave in very practical terms. They assume something like if the employee asks um, for time off and they're not looking to get paid, then it's not a big deal. But if the employee specifically asks for FMLA, then we'll go through the formal process of processing it as an FMLA leave, whatever that looks like in that organization. And again, as I kind of alluded to earlier, many supervisors may have the intuition that if the employee is not going to be paid for the time off, what difference does it make? Unfortunately, of course, for covered employers, the FMLA doesn't work that way. There are requirements to provide notice to the employee and take additional steps. So the big point here is that whether it's said to HR or another supervisor, the employee doesn't have to mention FMLA to start the legal compliance under the act. Many ways they could trigger those obligations on the employer's behalf include simple statements like, I'm having surgery, my doctor told me to stay home for a few weeks, I'm dealing with a serious medical issue, I need treatment and may be out for a while, and things like that. None of those statements specifically mention the FMLA, but they probably still trigger a covered employer's obligations. What those obligations are can depend on the circumstances. First of all, it is possible that the employee is not eligible for FMLA leave, and upon determining that, the employee can get notice to that effect, and that would effectively avoid the further FMLA considerations. But if the employee is eligible, they need to receive a notice of their eligibility with their rights and responsibilities, and you may potentially be requesting medical certification from the employee. Whether you request medical certification in every situation can vary from how your organization handles the issue, but that definitely is an option that is available and is typically recommended in situations where the medical issue is not already somehow clearly documented, at least. So Why does this matter? We're talking about a scenario where the employee got their time off and came back. Well, it's not so much what happens for that leave, it's more what happens in the future if the employee needs additional time off. So suppose the employee has taken the 3 weeks off informally and then 6 months later requests their 12 weeks of FMLA leave. Since the earlier leave was never designated as FMLA leave, there may be some difficulty in trying to convince the employee that they've already used 3 of their 12 weeks. Now, the legal aspect of that scenario is a little more complicated. There is some court guidance, including from the Supreme Court of the United States, suggesting that the employee is only entitled to 12 weeks of FMLA leave in a 12-month period, regardless of whether it has been properly designated. But that doesn't mean that the employee still wouldn't have a valid gripe, and they potentially could even pursue a claim just on the failure to give the notice and designations. In many of those situations, I think the employers are going to end up deciding that they should just give the extra 12 weeks of properly documented leave. But the better path would have been to have followed the right process in the first place and not have any doubt to say now you only have 9 weeks left. So, just to clarify on this first scenario here, what should the employer have done? The key would be to not immediately decide at the supervisory level whether the employee should get time off or not. You need to trigger the proper process. In most organizations, that's going to include a referral to human resources, or at least whichever person in management is responsible for administering those types of matters, such as leave and benefit time. So when a supervisor hears something like, I'm not asking for FMLA, I just need a few weeks off, that should be a particularly strong red flag that this needs to go through a more formal process. Even if they don't mention FMLA affirmatively or negatively, just saying I need a few weeks off for a medical reason would be enough that the proper channels should be followed. So the supervisor in these situations should say, thank you for letting me know. HR will follow up with you about leave options and any required paperwork. For example, that ensures that human resources, or again, the right management personnel, become involved early and can get out the proper FMLA notices and certification forms. At the end of the day, it should be the employer, not the employee, deciding what qualifies as FMLA leave or not. So, a practical take home here is if there's any ambiguity in your organization, make sure that supervisors who may be setting schedules know that whenever someone says they need to be out, especially for anything related to a medical leave or birth of a child or something else that might be covered under the FMLA, paid family leave, or some other leave policy, that they actually process it through the proper channels, whether the employee wants it to be so processed or not.